First, thank you for the opportunity to follow up with me with respect to Section 17 of the Procedures Bylaw. As remark, when I refer to Section 17 in its parts, I mean actually Section 16 in the second reading, just for clarity purposes. That's the public decorum at meeting section in the document posted in the meeting minutes at the time. I have many issues with the present bylaw, including recommendations to improve beyond this section mechanistically the communications between council and residents so both can do their jobs better. However, I'm allowed to speak to this specific part of the bylaw, so I will. Municipal governments, including that of the RM of Springfield, are democratically elected, responsible, and an accountable order of government, established and continued by the will of residents, and are also subject to the freedom of expression rights under the Charter. At the September 3rd meeting, I was told by you, the Mayor, that you would not violate Charter rights, namely freedom of expression rights, and also said the council you desired a robust policy to council and future councils. I'm speaking here as somebody who's watched some of the slippery language I discussed at the September 3rd council meeting proposed in Section 17, and seen them do a great disservice to other public institutions, such as to academic freedom and speech in Canadian universities, which is functionally important to such institutions. However, unlike those which may not recognize charter rights, this is a government institution which must uphold charter rights of freedom of expression. Such wiggly language, I'll remind council, can be used to censor or deny speech of residents which will violate their charter rights. As a principled academic and a service to my community, I successfully reached out to a subject area expert. So September 16th, council should have received a warning letter from Charter Advocates Canada. Charter Advocates Canada is a charity and civil society organization whose purpose is to uphold the enforcement of Canada's constitutional freedoms, civil rights, and human rights, including the freedom of expression. Their letter thoroughly cites constitutional issues with the bylaw and provides their legal analysis. It is worth noting, due to the scheduling around this policy, 2 weeks, these subject area experts could provide only formal comments to Section 17. I asked council to carefully review the letter, and should they have any concerns about the legal case law components, reach out to the subject area expert. They have identified 3 areas of concerns, the first being one I recognized last time. It's worth noting that 2 of these concerns actually exist presently in the procedure bylaw. The one I spoke to last time is being introduced into the procedure bylaw. So the first one is Section 17's use of harassment free, which is new language in the bylaw. Rather than reiterating what I said last meeting, I'll keep this brief. Members of the public come to this chamber to speak and express public policy concerns or issues in their community, a democratic setting. It is not a workplace for them, nor a private establishment. However, harassment is too vague and subjective and ambiguous of a phrase to belong in this bylaw. It places too much authority on accusations in the hands of the receiver of speech for a place such as the council here. And harassment itself often has a subjective component to it that even in today's usage can be loosely used when people feel uncomfortable. Being a safe and secure location, as this should be, the meaning of this phrase then is more restrictive than previous language that existed in the bylaw. This is the public place where discourse happens in a democratic setting, regardless if it's controversial or not. It may even be deemed objectionable. Furthermore, even more precise definitions would be insufficient to allow this wiggly language in this bylaw, as explained by the subject area expert, such as using the code of conduct. People come here to discuss issues and make decisions on matters in their community that needs broadest protections. As I've done in the past, some decisions in this chamber involve neighborhoods and the future, meaning residents may even come here very upset when they come to this chamber. It's too easy to abuse and to silence genuine and frank speech which may be heated, controversial, potential, and may potentially even contain flaws. Introducing this further restriction, as with the and, including, will only make things more difficult for both residents and council to do their jobs properly. In addition, the phrase that is, so now we're getting to the second item. The phrase that is already present under 17C of other behaviors which may prove disruptive. This section is too vague and ambiguous. I strongly advise reading the whole of the subject area experts section on this matter carefully. They address carefully what it's meant by this and what I was talking about last time as wiggly language. And they address this in rather strong terms. As with the first concern, there's a lack of a declarative standard to be held, which could be used for censorship against members of the public. This section, should it exist, should be far more precise so residents know what standard they're being held to and what is specifically disruptive conduct that prevents meetings from being orderly, because that's what matters most. It's about the procedure of the meeting. The third item is involving section 17D. So this is the one that's currently in the procedure bylaw and is in the current one that's being proposed. The subject area expert says this section is very difficult to justify constitutionally. People come to the chambers, which is a public place for public discourse, and speak to council. The public has freedom of expression in the chamber. If the mayor, so those are the three items. If the mayor wishes to have a policy that respects charter rights, as he has explicitly stated, all the changes recommended should be performed. At least that's my recommendation. To do otherwise would make the procedures bylaw, at least with respect to section 17, not a robust policy. This policy should be able to stand on its own without the guarantees of a verbal promise. In summary, the present bylaw bans forms of expression under 17D, introduces ambiguities in 17C, and establishes, as I've explained previously, a mechanism to stifle free speech of residents, whether it be disapproving of the speech or characterizing it as harassment or other behavior which proves to be disruptive. I want to see council and residents work together in this community and see better mechanisms put in place within the procedures bylaw to ensure that at least we're taking one step towards making a better community. I hope that this will, at least this will help produce one step towards that goal. Thank you very much. Have a beautiful day.
Your presentation there. I guess you still have time. Did you want to read that letter now?
Sure. If you want, I printed off copies of the letter.
I know it's just people, not all the people are going to have access to it.
Yeah,
So if you want to read it, then
would I be technically allowed to ask a counselor to read it by any odd chance? Because
you
might
can
read
read
it faster.
Just
than
read
I
the
do.
conclusion there, and then
Sure,
we'll.
I'll read the conclusion section.
Yeah.
Sure. 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 I'll read the conclusion section from the letter. So it goes without saying that the very legislative purpose of the RM, amongst other things, is to provide good government, where council's role is to carry out the powers, duties, and functions expressly prescribed, including to consider the well-being and interests of the municipality as a whole, in order to promote public trust and confidence in council and the municipality. In the impugned amendments addressed above, the referring to the ones I just discussed, they would not constitute good governance or a proper exercise of the powers and duties of council. To the contrary, it both outright bans a form of expression under section 17D and establishes other mechanisms to stifle free speech of residents. Council may disapprove of or simply characterize them as engaging in harassment or other behavior which proves to be disruptive. Such impugned amendments would limit council to consider the well-being and interests of municipality as a whole and would establish concerning unconstitutional limitations on expression. We implore council to strike the concerning provisions in the impugned amendments in its further review of the proposed amendments to the bylaw. Yours truly, Darren Leon.
Thank you very much. Any other questions from council? Mark?
Thank you, Mr. Mayor, and thank you, Mr. Page, for that presentation. In the Charter Advocates Canada letter to council, it says municipal council meetings are core public places for free expression, particularly to express dissent on matters important to the community as a whole. As the Supreme Court of Canada has held, a public place where historical use for free expression is made out, the public will have the freedom of expression in that place. So that's exactly what we're trying to uphold in terms of question period and other elements. In fact, I think, to be honest, I think we're setting ourselves up for failure if we pass a procedures bylaw that prohibits or eliminates the question period. In fact, I would challenge that this will go potentially to the Supreme Court of Canada through this organization to say the RM of Springfield is not upholding what was determined by the Supreme Court of Canada. Is that somewhat of what would come about, perhaps?
So I can't specifically comment on the question period component, but I most certainly can say that what was communicated to me is that if any one of these three things were acted upon by council, they would be sued. These legal experts said that they would be the first person to take their call.
Thank you.
Okay. Thank you, Mr. Page.
Very, very useful. Thank you very much.